Your strangers determining your financial stability and the time that you have with your kids.
Yeah, yeah, it's a lot. Welcome back, guys. Episode 5 here of Cases and Cocktails. We're here today, New Year 2025, and new beginnings and all that fun stuff. We've got a new set that we've got set up here, trying to change it up a little bit, make it right, make it a little bit better for y'all there as well. We do have, we've got a new year, new beginnings, but we've got a drink that sort of has to deal with maybe some leftover Christmas situation. What do you think?
Absolutely. We've got Jingle My Bells today, and this is for those of you that still have your Christmas trees up and still have your lights up like we do. Not because we're super excited that Christmas is gone, but because we just don't have time to take it down. So we can't let go of the holiday spirit yet. And this drink has almond milk, peppermint, and 818 tequila blanco.
So what is this? So it's a peppermint-based drink. Is that what this is?
It's tequila based with peppermint garnish.
What do you think about the peppermint there?
I think it's very minty.
All right. Well, I guess I can try it real fast and see if it's any good. Have you tried it yet?
I did. I had to taste it before we got on camera.
All right. Well, at least you can. At least your breath smells good after that, huh?
Mm-hmm.
What do you think?
Yep.
It's not bad.
No, not at all.
Not at all. All right. And you're not a big tequila fan, anyways.
No, not generally, but this is good.
All right. I love tequila. I'd rather tequila than anything else. Maybe we make you a bourbon one next.
Maybe.
All
I'm
right.
open to trying new stuff. No big deal.
Is that your New Year's resolution?
No,
It's not.
I'm not leaving that door open. No.
All right. That's fair. Well, let's talk a little bit about today. Let's talk a little bit about divorces and really just sort of what I think some people, some cases we've had that kind of deal with kind of the basics of divorce, sort of the timelines, what to expect, cost expectations, that sort of stuff. What do you think?
Yeah, just unpacking the divorce real generally. We'll talk about a few topics. Probably won't be able to get too in depth with them, but just to give everyone an overview.
That's fair. I'll start though a little bit, just real fast. Divorce in the state of Texas, you got to file. It's a lawsuit, just like anything else. You file it. The other party has to be served. Once the other party's served, then you have active litigation. We talk all the time, or at least I talk to my clients all the time about, in this great state of Texas, there's only 2 ways to get divorced. It's by agreement or it's in front of a judge, right? And that's sort of, I'll let you talk a little bit about mediation versus litigation and that sort of stuff. And then we can talk about how long some of these divorces take as well.
Yeah, I think one of the most asked questions that I get on consultations is, how long is this going to last? And that's just it's a setup, right? You can't really give anyone that answer, because if they tell you it's uncontested, and you tell them, hey, we can knock this out in 3, maybe 4 months, that will be the most contested case you ended up with. And they'll say, well, you said this is only going to take 3 or 4 months. But to get to your point about mediation versus litigation, like you said, there's 2 ways to get divorced, and it's either litigating, which just means having a hearing in front of the judge, or mediating. And mediation is one of the ways that we encourage clients to try to come to agreements. One of the things that I always try to explain is, you might not leave mediation with 100% of what you wanted, but it's the ability to have control over the stuff that's really important. So I try to get clients to focus on the top 2 or 3 things that are really important to them that are not negotiable. And if we can secure those in mediation, then I think it's a win. They generally won't end up with everything that they wanted, but then if they did, it probably wasn't a very good mediation for me anyway. Most people are upset when they leave mediation on both sides.
That's fair. I know that we've always told, we've we typically tell our clients here at our firm that, anytime two parents can be in control of the outcome of these cases, it's better off not only for them, but for the kids. Also better for them financially most of the time. Oftentimes, if you go to litigation, you lose that control, and so we use the mediation piece to be in control of the terms, and it's really nice because you have the ability to be as customized as possible, right? I know that I recently had a case where we've got a fully customized visitation schedule, and it's lengthy. It's lengthy. It spells out where and when you're going to drop the kids off. Not only during the school year, but during the summer, during the holidays. It's a unique situation because the parents they live a little bit further apart, and so we've got detailed sort of terms about who picks up and drops off based on the holiday and based on what time of year it is as well. And you're in mediation, you're able to do that, right? You're able to be more creative. And in litigation, typically, the court is less likely to engage in some of the work that has to be done to be that creative. The court doesn't have the same amount of time or bandwidth, and the court doesn't know the details about the case the way that you may, well, at least the way the parties do. But also in mediation, you're able to kind of discuss those details. And when you're in court, you don't have an opportunity to get up there and explain why, little Johnny or little Susie needs to get to swim practice or football practice, here and there, and the work and traffic and all the sort of things that go into it.
No, that's a good point, because something that most clients don't understand is that courts will limit the amount of time that you have for hearings, whether it's temporary orders or even final trial. And when they hear that the judge is giving us, when I say only 2 days for a final hearing in a divorce, they're like, well, what do you mean only? That's plenty of time. Like, no, it's not. It's just not. Between, legal arguments and objections and openings and closings, breaks and everything else, it's really just a few hours per attorney. You have to split that. And I don't know about you, but I have a lot of words when I go to court.
Yeah.
But those minute details sometimes get lost in the shuffle. You might explain it to the judge, but at the end of the day, the judge has to work within the code and can sometimes deviate it, but then they have to have findings in order to do that. And so you'll get much more customized orders that are, custom tailored to your family's situation in mediation.
Yeah.
That's super beneficial. Now, the problem is if you've got a party on the other side, or your own client even sometimes, that has unrealistic expectations or just wants their day in court. What do we say? That principles are expensive, right?
Yeah.
They just
Yeah.
want to go and prove themselves, that show the world that they aren't wrong about something. That gets expensive, and I think that if that's your focus, you end up losing overall.
No, yeah, I think you're 100% right. And I think too that, when you've got two parents and, you're sitting there, and you're trying to determine, are we going to be able to go to mediation? Are we going to be able to go to litigation? Right? It really does, come down to, are the parties willing to reach that agreement? I, you know, I, I oftentimes, I'll talk to clients and I tell them, I said, look, here's the situation, right? Like you've got, some facts and you've got a case and your opposing party, the other parent, your spouse, right? If they're not willing to agree with you, then we're not going to get an agreement. We're not going to be successful at mediation.
We can't make them give our clients what they want.
Exactly. And I talked to the clients and I said, look, I can agree with you, your mama, your daddy, your priest, Facebook, right? Instagram, they can all agree with us. I've had situations where opposing counsel has agreed with me, right? I just went and did a hearing. And prior to the hearing, we were trying to get it worked out. We were working to try to, not have to go to that hearing.
Mm-hmm.
And opposing counsel came to me the day of the hearing. We talked outside in the hallway before we went and had the hearing before the court. And he's like, man, I agree with you. I agree. I think the offer is great, and we could probably get this thing done. The bad part is though, and this is what I think what clients really need to understand is that you got to have an agreement, and that agreement it comes from or it has to be between husband and wife,
Right.
right? The spouses, mom and dad, right? The
Mhm.
parents. It doesn't matter who else agrees or doesn't agree. If those two don't agree, then you got to go to court. That's the only way to get it done.
And what becomes even more frustrating is then you go into court with that client who did have reasonable expectations and wanted to come to an agreement with an unreasonable opposing party, and then you get a ruling from a judge that no one wanted, right? That's always real fun. Then you
Yeah.
stand back out in the hallway with them and they're like, "What was that?" And like, it's the gamble. You go in front of the judge and you don't know what's going to happen. You can have the facts on your side, you can have the law on your side, and the judge is going to have their own perspective, and they've got quite a bit of discretion as far as what they can do in their rulings.
Yeah. No, it's true, and it's one of those things where, again, going back to what we tell them, anytime that the parties have control over the terms, the better off that outcome's going to be, and not just for the parties, but for the kids, for the parties financially, and you'll be able to put yourself in a situation to be successful, right? Once the case is over with. I want to talk real fast. One of the questions we get all the time is, how long is this going to take?
Yeah.
Right? How fast can we go? And
It's one of the most loaded questions we get, that's for sure.
well, and it is. And what's fun about it too is that we've been doing this for well over 10 years now, and we've got experience. And typically, you can hear what's going on in a case, and you say, okay, generally, I think I can get this done in X, right? I almost think though that as soon as you say that, you're cursed, and
100%.
it won't
100%.
happen, right? I've got cases where we simply just needed to enter an order. It was a very sort of cut and dry procedural situation where
Oh, you got on the case after it was over.
yeah,
Yeah, I know which
yeah,
one you're talking
yeah.
about.
And then and it took almost 6 months to get the order entered, right? Just because we
Fun
had
stuff.
to go to court multiple times. I've got one now that's the same way. And it's going to take probably another 3 or 4 months just to get it entered. I've had cases where we're fully loaded and we're strategizing. We're going to go to litigation. It's a fully contested case. We know that this case is going to last probably 6 months just based on the strategy that we want to implement to do it. And 2 months into it, I think the parties came to an agreement, and it was just out of nowhere. Like no one really thought or conceptualized that the parties were even close enough to conceptualize an agreement, right?
And they just figured it out on their
And,
own.
and they
Yeah.
just come to us one day and they're like, "Hey, we've got this figured out." And you're just sort of blown away, right? By how did that happen, right? And it wasn't even on the radar. And so, I think it's best that the clients understand and that y'all understand. I think it's best that the clients understand that the how long the case takes is really dependent upon the parties.
Absolutely.
And one of the things that we work on is we try to help our client navigate and conduct themselves in the best way possible to be successful in litigation, right? And so what does that mean? Well, that means, look, we're trying to help you manage what your expectations are, what you need to be focused on, what you need to be working on, right? Don't be focused on the lawn furniture, right? When we're talking about, a multi-million dollar, property, marital estate, right? And we're trying to divide that.
If I go to one more mediation where I have to hear about the PlayStation or the whatever the hell the video game console is, if I have to hear about it one more time, I mean, I've literally sat at mediation and said, how much is that thing worth? Okay. How much am I billing you an hour? How much is opposing counsel billing an hour? How much is the mediator billing an hour? If we talk about this for a few more minutes, you could have bought 3 of those things.
Exactly.
Like it just doesn't make sense, the things that some people focus on. And you were talking about timelines, and really the only timeline that we have that's codified is the 60-day cool off, right? So everyone says, well, there's that 60-day waiting period before we can finalize, so we can get it done in 61 days, right? Not likely. Even uncontested cases, for me anyway, they generally take, 3 to 4 months, and that's because they might think that they have an agreement on everything, but they don't really know what all they need to come to an agreement on.
Right.
Like, oh, okay, well, this person's going to be primary and we're going to do this kind of visitation. I'm like, okay, now let's get into 153, 132s. Let's talk about rights and duties and, all the other details. And that just takes them some time to get together to come to agreements. And then we have to draft it, circulate it. It takes time, but I try to explain, I understand that you want this case to be finalized. You want to be divorced, or you want this custody battle to be over. But think about the decisions that we're making. Think about the impact that these choices are going to have on you and your kids. Let's take some time and think about it and make sure that we get it right.
I appreciate that probably more today. I recently have had a couple cases that just finished over the new year, or at the beginning of, or at the end of last year, coming into the new year, and there are cases that they took probably a year plus to litigate and to navigate for us and for the client, and we put a lot of time and effort in positioning our client to have an outcome that they were not only okay with, but that they could be successful with. And my point of all this is, we spend all that time and effort, and we get in there, and we do it. But just because there was the end of the year, everyone started rushing at the end, right? And to, just back to your point, which is, don't rush it, right? There's a lot of details. There's a lot of things. They say, the devil's in the details, and we talk about it all the time, right?
Yeah, absolutely.
But don't do yourself the disservice, right? And clients sometimes out of haste and just wanting to be done. And I get it. No one wants to be in litigation, right? No one, when we meet people, we tell them, hey, here's our card, or I hope you don't ever have to call me, right?
Right.
And that sort of stuff. They're not calling you because they want to. And I get that, but
I think there's something. I think that's why our Decembers are so hectic. It's because I think there's a psychological aspect to it. You said at the beginning of this, new year, new setup, we're doing some new things here. I think for people, they just feel like if they can have the litigation behind them, they can start the new year fresh and things will be better. But if you do that, it can be detrimental, obviously, right? If you do it just to speed through it and don't take the time to sit down and make sure that all the details are hammered out, then you're going to end up with more problems in the new year, and you're going to be mad when you have to come back to me to file a modification right away.
Well, and it's about being successful too, right? Like you want to be successful, not just during the litigation, but on the back end. On the back end, that's where we go away. Right. The spouses or the parents, they're left right there to navigate this on their own. And so if you're out of haste, you sort of run through those details right at the end, you're going to miss something.
Yeah.
And I think it's important that you give yourself the best chance possible, right, to be successful on the back end. Make sure those details are taken care of and that sort of stuff. I want to talk real quick about what happens. Just like I want to say this too. Sometimes you think the case is going to go right, and this is a highly contested case. This is going to happen. You start gearing up, and sometimes it happens immediately, and sometimes this happens sort of. You're 6 months into a case when the parties reconcile.
Yeah.
And they get back together. And so now there's no need to be in this lawsuit, this litigation. They don't need to fight anymore. That drastically changes the timeline. One,
yeah, absolutely.
I think for the most part, what we try to tell them is don't non-suit the case. Don't give up all the work and effort you've put into it. Just put it on hold.
Yeah, we don't want to discourage people reconciling, but we're that one person's advocate. We're not the couple's advocate, right? And they've already invested time and money into filing the divorce. Just let it sit for a little bit, because we've had We recently had a client come back to us and we refiled for divorce, and that person hired us maybe a little over a year ago.
Yeah.
Then they were reconciling and now we're back in the same spot. But that client now has to pay filing fees, service fees, and fees for us to do all the legwork at the beginning over again.
Right.
Hiring an attorney to do a really contested divorce is an investment.
Right.
So don't just throw that out the window because you think this is going to work now. And we do hope it works. It's, that whatever at the end of the day is going to make the client happy is what we want. Right. But we just want to protect their investments.
You said, you want them happy and we don't want to discourage it. But man, I can't tell you how many times I've seen the other party suddenly want to reconcile and get back together to level the
playing field. As soon as we have leverage,
I was going to say,
as soon as
just to level
good.
the playing field back, right? And then that way they can try to come back in and be in a better position next time that they want to file for divorce or whatever it is, with a custody case. And so, all right. So first of all, New Year, 2025. Mm-hmm. Do you have a New Year's resolution? It does not look like you have a New Year's resolution.
No, if this year could be easier than last year, that would be great.
Yeah. It's not going to.
I know. Less dumpster fires would be cool, but I don't know that I have control over most of that.
That's fair. Well, it is the new year. And one of the things that we want to do is try to answer some questions that we get frequently, some questions that we get off the comments, different platforms. We want to try to answer the questions that everyone's asking, right? That y'all are asking, right? We want questions that are out there and try to get to those. So we're going to do a handful of these. I'm going to ask you a question, and then maybe you can ask me a question and see if we can answer some of these. Is that fair?
Okay.
All right. I'm going to ask you the question first.
Okay.
All right. In your opinion, what is the average timeline for a divorce in the great state of Texas?
Well, I don't know about the whole state. And I, just based on everything that we just talked about, obviously it varies quite a bit. But I would say for a divorce, most divorces happen without lawyers even being involved.
Right.
So when the divorces that we deal with are unique because there's generally high asset value or really contested issues, and all the fun stuff that comes with that. Right. But I would say on average, probably 6 months to a little over a year. We've got the one-offs on either end of that.
Right.
Some that are a little bit shorter, some that are much, much, much longer.
Yeah.
But I would say 6 months to a little bit over a year is probably a good median range.
That's fair. Before you ask me my question, I want to talk a little bit about something that you brought up. A lot of times in the great state of Texas, people get divorced and they do it all on their own, right? You look, man, you go online, you find the forms, you do the stuff. It's okay. But I want to talk about, because you had this case, and it's a story about why you might want to think about hiring an attorney, at least to look at things, right? Yeah. At least to look at things. You probably, I think it's a great cautionary tale, right? So you had a case where the client had come to you post-divorce, right? Or what they thought was post-divorce. And they said that they were divorced, but they weren't really sure. They had issues and they needed a modification or enforcement or something, right? Mm-hmm. And come to find out, though, that the entire divorce decree was made up. It was fraudulent.
Well, pieces of it were. So like a judge, these parties had what they thought was an uncontested divorce, and husband and wife, I don't know how they came to drafting or getting this order, but she, at the end of the case, she received a copy of what she believed to be the final decree. And it had everything in there that needed to be in there. Everything from asset division to conservatorship, child support. Well, what she had received was a doctored decree. He had added pages in there that weren't in the actual file stamped copy with the clerk's office. And so she relied on this order that she received from him. And in reality, the judge made 0 decisions as far as kid stuff was concerned. There was nothing in there about conservatorship, child support,
Okay, hold on.
health
All right,
insurance.
so you're saying the parties got divorced. They did it themselves. They had some agreements. And then the judge, though, entered an order that didn't have the kid stuff in there,
One
right?
of those fun out-of-state ones where you're like, what judge would have signed this? And
Right.
it's lacking all the kiddo stuff. Like the version that the judge actually signed that got filed with the clerk's office had no kiddo provisions in it.
So the judge never saw it. So the judge just thought, hey, these people are getting divorced and signed it off. But then the other party
Slipped in additional pages to make our client think that all of this stuff was resolved.
and then sent it to our client.
Sent it to our client. And so when opposing party got behind on support and there were some other issues, she wanted to enforce it, but she couldn't because those parts were missing. And she had consults with tons of other attorneys, and she said that she just couldn't get a clear answer. And I vividly remember doing the consult, and I thought, well, there's not been a SAPS or there's not been a custody case. So let's just file that. And so we did and went in, and I mean, the judge in the local county was blown away by what happened. And that was kind of a slam dunk litigation wise once we figured out what we needed to do. But it's one of those unique situations where, she wasn't represented. And so she didn't have someone not just to advocate for her, but to make sure that she wasn't being lied to about what was going on.
Yeah, exactly. I mean, I think that's, you brought that up because we were talking about timelines. First of all, those two parties thought that was a pretty easy divorce and it was a pretty short timeline, right? And it actually took them much, much longer.
Years.
Right? But more importantly, it also cost them a lot of time and money and effort in order to sort of fix those problems.
Yeah.
So I think it's important. I just think that it's important that particularly y'all out there, when you're thinking about doing it on your own, and you can, you might want to have someone, though, make sure that it's being done right, because it affects you, it affects your kids, it affects your finances, and it's extremely costly and difficult to undo, right, once it's done.
Yes.
All right. Give me a question. I guess it's my turn.
Okay. Let's see. One of the common questions that we've received, we've gotten this one actually numerous times, is how does mediation differ from litigation in a divorce case?
Well, we talked about it a little bit earlier, and I think the best way to put it, as we said, in mediation, you've got control. In mediation, you have the ability to dictate the terms of your agreement, and that may mean you get to have a say in how you exchange your children, where you exchange your children, how often, the holiday schedule, extracurricular activities, all sorts of stuff can go into that. And mediation allows you the ability to it allows you the runway in order to be able to address all those. Mediation's great because one of the things that I tell my clients is that, hey, look, you don't have to agree to anything today. You just don't. There's nothing that forces you to come to an agreement in mediation.
It's a good time to listen, though.
But it's a great time to listen, and it's a great time, too, to sort of think about what it is that you're trying to accomplish. I know you said earlier, too, there's a lot of prioritization about what we're trying to accomplish in mediation as far as specific things that the client wants, right? What's more important than other. But mediation, it's an opportunity to really resolve the case and have control over the outcome in some capacity.
And even if you don't settle, like I said about listening, it's an opportunity for you to really gain line of sight as to the true goals of the other side.
Right.
Because all the discovery or legal documents might say one thing, but when you get into mediation and offers start going back and forth, that's the opportunity to learn what everyone's prioritization of the issues really are.
Yeah.
But, like you said, mediation is a vehicle to come to an agreement, and then litigation is when you just can't. It's the last resort.
Yeah, like I said when we started talking about it earlier, there's only two ways to get divorced or settle a custody case in the state of Texas, and that's either by agreement, which is through mediation, or informally, and the other side is to go to court. And so oftentimes we tell clients, look, these decisions are made for us. If the other side's not going to agree to the terms that we're comfortable giving and we're comfortable agreeing to, then the decision's been made, and we're going to go to court. And that's the litigation piece. And when you go to court, it's not Law and Order, it's not Perry Mason.
I feel like it is sometimes when I go, but
well,
maybe that's just my perspective.
That's just you. I just think that at some point it's very stressful. And there's a lot of work that goes into it. And at the end of the day, you either have a judge or a jury making some decisions about your livelihood, your life savings.
Your strangers determining your financial stability and the time that you have with your kids.
Yeah, it's a lot. But that's it. And those are the only two options. And so one of the things that I think it's important, though, is that clients need someone to help shepherd them through those processes and help them understand when it's a good time to mediate or come to an agreement, and when you have no other choice but to litigate.
And some courts take the option away from you and say, before you get on the trial docket, you got to go try mediation anyway.
Yeah.
Yeah. All right. Ask me another one.
Let's see. Give me two common mistakes that you see people make in the divorce process.
Well, we already talked about, rushing through to get to the end. So I'll give an example in contested and uncontested divorces. Or actually, I'm going to do an example for clients that are represented by attorneys versus people doing it pro se or doing it on their own. The common issue that I see with people that are trying to do it on their own is leaving important stuff out.
Yeah.
Not like the case I just talked about where there are some nefarious actions by one of the parties, but you don't know what you don't know. And I have to explain that regularly to people. And, even the ones that come to us with agreements, like I said, yeah, you think that you've agreed on everything, but you don't even understand what all you need to be talking about,
right,
what all needs to be decided. So you go do these decrees that, either are check boxes or, that they found online. And, some judges are really good about going through those line by line and letting you know what's been left out. And some judges will sign it and say, this is your agreement, so go ahead. And then they realize that there were some key issues that were left out that could be really impactful for them.
Yeah.
Biggest mistake, or one of the mistakes, if you're represented by an attorney, is, I think, the focus.
Mm-hmm.
It is. I regularly try to adjust people's focus.
Right.
People going through a divorce or a custody case have hired attorneys, are spending tons of money, time, effort, stress, and they're really focused on that, or they're really focused on what the other person did to them to end this relationship. And the focus of hurting that person or showing the world who's right. I understand that from an emotional perspective, but we've got to table the emotion, and we've got to focus on the important stuff. To make sure that you can be as successful as possible moving forward.
It's really, the focus needs to be looking forward, not back.
Yes.
Right. You got to, look, hey, I get your ex, right? She was a bitch or he was an asshole, right? And they did X, Y, and Z, and we're going to, we're going to fight about that. I talk to my clients often, no matter how you got here, right? You got here, that's over with. It's done.
Right.
Let's focus on what we're doing moving forward. How are you communicating with them? How are you communicating with them about the children? How are you, handling yourself, right, with the children, or engaging with your ex? Yeah, it's a lot. It's a lot to focus on, because they didn't get here just because they woke up and everything was fine, right?
Right.
So now getting them to focus on the right thing. I'll tell you, one of the things that I see people make mistakes. I see, right? I see people making mistakes all the time. What they do is they, and I know this sounds sort of self-serving a little bit. They'll just hire an attorney, the first attorney that they see or they find that will talk to them on the phone because they're in an emotional state and they're freaking out.
I don't know
Right?
how many consults I've done where the person wants to know if that guy on the website with the beard is a biker. I did that consult last week, and I was like, no,
No,
my husband
no,
doesn't have a motorcycle.
no. I can't. I can barely ride a bicycle. Let alone
But
a
that's why they
motorcycle.
picked up the phone and called us. It's crazy.
I just think that it's important that you find an attorney that works with you,
Yes.
and works for you, and
It's a relationship.
yeah, and you want to have someone there that you can relate to, that you also trust.
Yeah.
We get a lot of calls. People have spent a lot of money with other attorneys, and it wasn't that the other attorney did a bad job. It's not the other attorney wasn't qualified or couldn't do it. It's just that the two of them, the client and the attorney, they weren't on the same page. And you can see the amount of time, money, and effort that was spent to move the client really in a direction the client didn't want to go.
Right.
And so at the end of the day, now they're with us, and we kind of got to go back and fix that, and then also start focusing on the things that the client wants. And so
Increases the cost and the
Yeah.
length of litigation.
yeah, and so look, take your time, make sure you got a good fit. And if it's not a good fit, just say words. And if you can't get it figured out, then find someone that is a good fit. So, all right,
Final question. You
all
ready?
right, all right. Last one.
What are the typical costs involved in filing for divorce?
Man, in filing for divorce, you've got the petition for the divorce. That's a couple $100, $250 or so.
The filing fee.
The filing fee to file the petition. From there, you're going to have someone serve it on the other party, and that's typically going to be about $100, $150, depending on the process server and how difficult your ex is to do that. There's ways to save it. You can if the other side's willing to sign a waiver of service, you don't have to do that. You don't have to go through the process of having them served. That sort of stuff. But that's really the filing fee amounts are pretty much limited to that, I think. I don't think I missed anything, did I?
No, I mean, as far as just actually filing for divorce,
Yeah.
those are the ones that, and if there's an issue with your ability to pay those filing fees, you can fill out an affidavit of an inability to pay. And you put some of your income information on there, and that filing fee, I think, can either be reduced or completely waived too, if that becomes an issue.
Yeah. All right. I think that's all the time we got for today. What do you think?
Absolutely.
2025 good so far?
So far,
All right. What do you think about this setup?
I like it. I think we're going to
Yeah.
have to go home and take the Christmas tree down, though.
No, I don't want to.
It's a live tree, and it's not doing well. I think it's a fire hazard at this point.
That's fair. All right, guys, thanks for joining us. Episode 5, Cases of Cocktails. Look forward to seeing you back here again for episode 6 coming down the line. Y'all take it easy now.